It's my pleasure that I have been a part of CAHO since the last few months, and it's been quite a eventful 2 months. I'm sorry I was not able to attend the conference, but I thank Dr. Aparna for giving me this opportunity to introduce a new burning topic that has come into the lives of doctors. Few years back, doctors were equivalent to what gods were. Like, all our patients used to treat us as gods, and we are second to God, and we could do anything. But in the post-COVID era and in today's times, when it's become very easy for the people to jump to the court for any small, minuscule matter also, medical legal has become a major topic that has come into play in today's diagnostic or healthcare world. And since medical legal is becoming a big question, every other day we are seeing in the newspapers that there are articles where a doctor has been sued for some particular matter or some hospital has been sued, brought up in court for some medical negligence. Now, there is a bit of lack of awareness regarding medical legal aspects of how a person can sue, or what are the things that a person can put up in court, or when is a doctor liable for such actions of his, which come under the acts of medical negligence. So, I thank Dr. Aparna for giving me this opportunity to start a medical legal series under the CAHO banner, because CAHO itself is committed to healthcare. And since if we maintain our standards of quality and standards of treating patients, it would become so easy to do not face such litigations in the future. So, Dr. Aparna, thank you so much. And I'm obliged because of Dr. Aparna, Dr. Mamta, and Dr. Preeti to start this medical legal series. And today is the first introductory lecture. I think we should go ahead with the topic, and today's topic is related to one thing which is a very common thing. पहले के जमाने में ऐसा होता था कि everyone said कि आप consulting room में आते हो, that itself is a consent for practicing. But in today's world, consent itself needs documentation, which is something very new for a consultant. If you're talking of tier two, tier three cities where hospitals or clinics are working, people still are not aware about what documentation related to consent is all about. Consent क्या है? तू तो आता है बोलता है वो consent ही है ना. But that is not the fact. There are lot many things into it, and I have a learned speaker with me, Dr. Gopal Shah. I'll give you a brief introduction about Dr. Gopal Shah. He, by profession, is a neurosurgeon based out of one of the leading hospitals in Ahmedabad. He's quite experienced in his field of neurosurgery, and his specialization is in epilepsy. He has been associated with multiple hospitals across the globe, specifically Hinduja Hospital in Mumbai, followed by a trip to USA, then in Australia, London, and he is trained in epilepsy surgery in London as well as the Chitra Institute in Trivandrum. But that is not what he's focusing today on. So it's something what we all are very passionate about. We have studied fellowship. We have done a fellowship in postgraduate medical legal policy and ethics from the famed Gujarat National Law University, which is one of its kind in Gujarat and one of its kind in the country also. So just to brief all of you about what consent, and I think Dr. Gopal will be the best judge about it. We can continue with the lecture, and if you have any questions, we can answer the questions after the topic is over. I think Dr. Gopal, if you can take this ahead.
So good afternoon, everybody, and thank you, Dr. Piyush Patnaik, for my old friend and senior and colleague now for such a nice introduction. And thank you, CAHO, for giving me this opportunity to talk on such a national forum, which involves major hospitals and administrative side. Uh, as Dr. Piyush just told, like we did our PG diploma in medical law. Hello.
Uh, yes, sir. We can hear you now. For
Okay.
a second, we lost you.
Okay. So as Dr. Piyush just mentioned that we did our diploma, postgraduate diploma in medical law ethics from GNLU. Luckily, we were part of the first batch who went through this course, and we learned a lot of balls of wisdom that probably we should have been taught during our medical school or early medical practice. Unfortunately, it's too late, but late is better than never. So this is a basic thing about the consent. And before, like, I'm practicing neurosurgery since 22 years. So we've been doing a lot of paperwork regarding the medical legal things, regarding the consents, regarding all different documentations. Still, we lack a niche in the documentation and the consent for all of us, including the clinicians, the paramedical staff, the administrative staff. It is just a piece of paper. Whenever there is a chaos in the hospital, whenever there is a medical lawsuit, the first thing we ask is consent liya tha ki nahi liya tha? And somebody would say yes, consent liya tha. So we feel safe. They say, okay, consent liya tha, so we are safe. So just want to clear some myths and facts about the consent. And what are the types of consent and who should be taking? I'll be discussing, if the time permits, I'll be discussing few cases which are landmark cases in India as well as abroad, which change the mindset of legal framework when you're talking about the consent in medical practice. So that's the whole class, whole batch, students starting from 40 to 60 years of age, who did our we did our diploma from GNLU, one of the prestigious national law universities located in Gandhinagar, where me and Dr. Piyush, we both were students. There are no financial interest. So, like, coming to the topic straight away, why the consent is necessary? Like, as we all think, consent is necessary to safeguard the order, consent is necessary to prevent litigation, consent is necessary to prevent malpractice, insurance claims, consent is necessary to save our practice. But probably there are a lot of things much beyond what we normally feel. So the first and foremost is the greater patient safety and satisfaction. When a patient comes to us for treatment, whether it is a medical treatment, whether it is a therapeutic thing, whether it is a surgical thing, whether it is a diagnostic thing, patient satisfaction, obviously we want, but patient safety stands first. That is the MCI ruling, that is the Supreme Court ruling, that is a ruling from most of the courts all around the world. Because the patient is coming to a doctor or a hospital for treatment and getting better. It's not always necessary that the patient would get cured of the disease, but a clinician, a doctor, a institute should make sure that we don't end up giving more troubles to the patient, which could have been avoidable. Complications are inevitable in medical practice, but avoidable complications should be avoided. Obviously, the more robust paperwork we do, like you've been listening before a decade that in Western world, when you go to a hospital, they get you sign a bunch of papers, which takes half an hour. You read it, you don't read, it doesn't matter. Now we realize what was the importance of those papers, because finer details have to be disclosed to the patient and the family before they get admitted for treatment or OPD treatment. Obviously, the legal requirements. So we are talking about the safety, then we are talking about the ethics, then we are talking about the legal requirements. There comes the role of consent to reduce the possibility of our litigations. Obviously, harmonizing the things. When an institute like where I'm working, KD Hospital, there are all specialties available, starting from basic specialty to lung transplant, heart transplant, and whatnot. If there is a format implemented from the management, from the administration, from the quality control team, that these are the necessary checklist before the patient goes to an operation theater. This is a necessary checklist before the patient goes to an investigative segment. Then there is high level of quality maintenance when you're talking about quality, when you're talking about NABH, when you're talking about GCI, those things matter most. And obviously, as there is less number of medical lawsuit litigations or malpractice litigation, they'll be saving time, they'll be saving money related to litigation. So consent is a legal requirement. We consider consent is a formality before doing any procedure, but consent is a legal requirement, not just a formality. So as we, like most of us know, I would not say everybody, that we feel consent is just giving before a procedure, just before the patient is entering the operation theater, giving a form to the family. They just go through it roughly or randomly, just the way we we see those banking papers or insurance papers or some major purchase papers. We don't read everything. We just sign it. And when the problem comes, then we claim that we were not given proper information. The opposite party always has got a point that we gave you the paper to sign, which you signed on your own when you were fully conscious and you were normal, you were awake. So the liability is on your end. So that's not what our law says. It's much more than signature on a piece of paper without in-depth explanation. So there comes the difference between a consent and informed consent. If you see, the heading is informed consent. So the difference between consent and informed consent is what we need to understand today. So I'll go word to word because this is what it has been written by in MCI regulation, which is now obviously NMC. So before performing an operation, the physician should obtain in writing the consent from husband or wife, parent or guardian in case of minor, or the patient himself, as the case may be. So before any operation, when we say operation, it's not all about taking knife and cutting patient's body. It's all major invasive diagnostic is also an operation. So consent from patient, the fourth line, patient himself, as the case may be. That is very important, and that catch I'll tell you when we discuss some cases. In an operation which may result in sterility, the consent of both husband and wife. As we all know, that sterility operation cannot be done without taking consent of both the spouse. Now, just a brief about this is something obviously new for this August audience, Bolam versus Bolitho. So these were the two landmark cases on which the medical lawsuit decision making was or is based. So the Bolam test is not a test. Actually, it was a case back in 1957 in UK, where Mr. Bolam was admitted in Frayne Hospital. He was suffering from schizophrenia. He required repeated ECT, the electroconvulsive therapy. And one bad day, he was being given ECT. He fell from the table. He fractured his multiple bones. So the family sued the hospital that why did this happen? So initially it was thought that it was doctor's fault, that he did not give enough muscle relaxant before this. He did not explain the procedure properly. They did not have the patient restraint by which the patient would be tied to the table. But then eventually the Bolam test is when the doctor has acted in accordance with the responsible body of medical opinion. So if most of the people, like we must have seen old time jury in our medical system, in our law system, where most of the people, when they feel that I would also have done the same thing if I was the treating doctor, or Dr. Piyush would say that I would have done the same thing if I was treating the doctor, I was treating that patient, then it is assumed that doctor did something which was appropriate, correct in that situation during that particular period. So then the doctor would escape from any liability or malpractice litigation. That was in 1957. Now, 20 years later, another thing turned up. Like Bolitho test is again a case, a small child, Patrick Bolitho, was admitted in a Hackney hospital, again a case in UK. Now, that time, the child had repeated respiratory distresses, and they called upon the doctor. Doctor came to see once, twice. The child was stable. Again, the patient had a respiratory distress. We are talking about 50 years back, when they were working on pager system, or there was no communication system in the hospitals. In the last time the patient had respiratory distress, the nurse called upon the doctor, the resident doctor. She didn't turn up, and the child had a respiratory arrest followed by cardiac arrest. So then it was said that if at all the doctor had come during that respiratory distress period, again we are talking about 1977, when there were not a lot of technical advancements. Even the doctor would have been there sitting next to the patient. She would not have intubated the child, and the child could have had cardiac arrest. So if we consider the Bolam test, then what the resident did was correct. But then if we consider that if the doctor was present at the time when the child had cardiac arrest, then possibly the doctor could have done something extra which could have saved the life. And unfortunately, Patrick had hypoxic brain damage and it became debilitated. So Bolam test is what, in accordance to the medical opinion, like we take opinion of people of the same caliber, same education, same experience, and then we follow the advice, or we follow what most of the doctors agree. While in Bolitho test, or the Bolitho case, in the rare cases where the professional opinion is not capable of withstanding logical analysis. So if the professional opinion from 8 or 10 doctors, they give the same opinion that I would have done the same thing, I would have done the same thing. But we need the logical basis. So that was a grand addition to the immunity of doctors against litigation. That was in 1977. If you got some time, I'll just describe this case, which is really important. It's a neurosurgical case. Dr. Piyush, do I have 5 minutes to describe the case?
So I think let's go ahead.
Okay. So this was a judgment analysis from Pennsylvania, USA in 2017. The case goes like this. The patient's name is Megan Shinell, and the respondent, Dr. Stephen Toms. So Dr. Stephen Toms was a neurosurgeon, and Megan Shinell, she was a patient suffering from a pituitary adenoma. So it's a brain tumor from pituitary gland. She had undergone a surgery previously, which had residual tumor, and then she had a recurrent tumor which grew, and she had significant visual problem. So the case was like this. She consults doctor, and the doctor advised her surgery. Obviously, a pituitary macroadenoma, which is recurrent. So second surgery, there is a lot of fibrosis. The tumor was encasing the carotid artery. The tumor was encasing the optic nerve. So obviously, it's a high-risk surgery. So the doctor gave detailed things to the patient, Megan, that there were two options. Either we do a aggressive surgery or radical surgery, which obviously has got some extra risk of complication because of the damage to the optic nerve or the carotid artery. The second option would be to go a conservative surgery, where we go in, we do a partial resection to reduce the complication, to reduce the side effects and adverse outcome. And whatever the residual tumor is left, we will treat with radiation therapy. Unfortunately, in Western system, as you all know, that the first consultation, second consultation, the pre-operative consultation, they are gapped a few days. It's not like what we do in India. So then finally she agreed for surgery. Megan's husband, she called doctors, secretary to confirm the dates, and patient underwent surgery. Now I'll skip a small part which I'll discuss once we finish this case. So we all understand that she had a recurrent tumor, high risk with surgery. Patient wanted a radical surgery because she didn't want to undergo a third surgery. Patient got admitted on the day before surgery or the day of surgery, and she underwent surgery. Unfortunately, she had a complication during surgery. There was an injury to the carotid artery. There was injury to the optic nerve. She became hemiparetic. Later on, they sued the hospital and sued Dr. Toms. What they said, what the husband said, that although at the time of the first consultation, we had told the doctor about radical surgery, just when we got admitted for surgery, we told the assistant or the secretary or the theater nurse that we want to undergo a less radical surgery. We don't want extra risk, extra complication. So, and that was true, that was fact. So the problem was that doctor was always under impression that he's supposed to perform radical surgery in the best interest of the patient. The family had a different wish at the time of consultation and different wish at the time of surgery, which was not appropriately communicated to the doctor. It went to the federal court, it went to the Supreme Court. Eventually, the doctor and the Pennsylvania hospital both were held liable for this problem. They were held liable not for the complication, they were held liable because of poor communication. Because complication is something which is inevitable. Complications can happen. But if it was patient had asked for a radical surgery, then Dr. Toms would not have been in trouble. But because the patient finally told that they want a conservative surgery, still it was a radical surgery, which created problem to the patient, problem to Megan. So the doctor was held responsible. So the catch in this is the doctor should always do something in the best interest of the patient after consulting the patient, after counseling the patient, and after knowing what is their wish. It is not always necessary to embark our opinion, our decision to patient unless they understand the pros and cons of every treatment. So coming back to this, in between, I'll keep discussing the cases because I don't want to just harp on with all theoretical things. I'll discuss few cases in between so that you understand the importance of each and everything. So obviously, consent is a process of communication between the physician and patient that results in patient authorization. So in a legal term, in a medical term, we call it consent. In a legal term, we call it an agreement. So agreement is not only in the business, agreement is not only in shops, agreement is not only in the court of law, agreement is also in the hospital. So it's an agreement between the patient and the physician. So here we'll say physician is doctor, is surgeon, is radiologist who is doing an invasive procedure, is an anesthesiologist who is doing lumbar puncture, is a pathologist or a blood transfusion specialist who is transfusing patient with components. So physician is a generic term that we'll be using. So it's an agreement. So when there is an agreement, when you say agreement, it is a both the parties agree, then only it becomes agreement. If it's a decision imposed on somebody, then we cannot call it agreement. So when there is a failure to comply to the definition of agreement between the physician and the patient, doctor is definitely liable for negligence. So if it's a civil negligence, then obviously it has to be compensation. If it's a criminal negligence, which is luckily now very less common, doctors are being punished for the criminal negligence, then they are liable to be charged with imprisonment. Now, what is civil negligence and criminal negligence? Obviously, this is out of the scope of this lecture. Probably Dr. Piyush will explain it some other day. So first, I told you the MCI ruling on consent, and now this is a law on consent. So something which has come from the medical side, something which has come from the law side. So what is a law on consent? A medical practitioner shall provide all relevant information. So again, there is a catch. Again, there is a gray zone. Again, there is a question mark. What is relevant? What is not relevant? If I explain the patient all possible theoretical complications written in the books, then it is more likely that patient will be scared, patient will go to some other doctor and they will get treated or operated there. So that's the fear. That's the fear in all clinicians, maybe me also and everybody. But how to titrate, how to optimize the way you explain the complications, the way you consent the patient, the way you disclose the relevant information. So that's what the consent is all about. Now, in the current era, like if you see, usually, I'm not blaming anybody. Usually, a nurse or a junior assistant doctor would go to the patient's family, hand them over a couple of papers in, say, a patient is from Rajasthan, their vernacular language is Hindi, and they will hand over a paper in English or some other language. The relatives don't read it because they can't read. Even if they read, they don't understand. Just sign it. So we give them 2-3 options and then we tell them that you have to undergo this. Whether it is a consent, the answer is no. So what are the therapies, benefits, harms, risk? Everything has to be explained. I know it is a tedious process. I know it takes time. It takes at least 15 to 20 minutes in your busy running clinics, but it is necessary according to the law, according to the MMC. Now, from where did the concept of consent came? Now, consent is like in day-to-day things, like we talk to somebody, if you want to join me for this, that's a consent. Everything started in 1930s and 40s in World War era, where after a lot of human experiments or the gas chambers that happened in the Second World War in Germany, there was a unanimous code which was described, which is known as a Nuremberg Code, where consent is necessary. The humans are not to be subjected to any research. What we normally call that humans became the guinea pigs, but guinea pigs are also live animals. So consent is necessary, and that was decided back in 1947. So more than 75 years back, it was decided. Then came a lot of other rulings like Declaration of Helsinki, where the World Medical Association agreed that consent is necessary. The Nuremberg Code was primarily on the humanitarian ground or ethical ground. Now, in '64 it became on a World Medical Association, and in 1991, see, I just mentioned four, but there are a lot of other landmark opinion decisions or agreements at a international level, which consider the consent to be highly necessary. So harmonization of GCP, so that is a good clinical practice. So it's a free consent. So we talked about consent, we talked about informed consent, we talked about free consent. So these are the words that we need to remember when we are thinking about consent in a medical practice. So what are the consent processes? I'll just give you a brief why the case of Shinal versus Storms. There is another case I'm going to discuss, which was a landmark case in Indian medical system, which is Prabha Manchanda case. So patient prudent and physician prudent. The point is, physician prudent consent is like the US system or UK system that they used to follow, where the patient, say for the patient comes to me for a brain tumor surgery, or let's say for appendix surgery. So I'll tell the patient that you are suffering from appendicitis, acute appendicitis, and you need surgery. So that is a physician prudent consent. That physician conveyed the information that you have this problem, you need this surgery. Then the patient would ask question, do I definitely need surgery? What are the options? What are the alternatives? What if I don't undergo surgery? What if I wait with medicine? What if I what are the options for surgery? Is it open surgery, laparoscopic surgery? What are the benefits? And as the questions are being asked by the patient and the family, the physician would answer. So the physician would answer only the questions which are asked to him. That's what is called physician prudent. Still in UK, that system is prevalent. Now, patient prudent is where the patient has to be given each and every information. That's what we follow. We need to follow, and everybody at least should follow. Where the patient has to be furnished with every information, like what is starting from what is appendicitis, and it is always better in current era of audiovisual and internet. You need to explain the anatomy, you need to explain why the appendicitis happens. Again, you'll all think that this is a boring thing, and for appendix thing we should not spend 15-20 minutes or half an hour explaining. Even if the patient doesn't understand, even if the patient has very low IQ level, I say family, we need to furnish the information. Then what is appendicitis? What is appendicectomy? What are the options? What if we don't undergo appendicectomy? What are the complications? What are the common complications? What are the rare complications? So everything has to be explained to the family. Everything has to be written as we explained, and then then the family signs. That is known as a patient prudent. So these are two different processes. The physician prudent consent is good for physicians. They don't spend much time in counseling. They don't explain much, but it is bad for the medical practice, but bad for the medical uh, fraternity, because it reduces the confidence, it reduces the level of satisfaction for the patient and family, especially when when the patient gets some complication. So, informed consent is not informed unless it is properly informed. So, as I told earlier, what is the optimum information that you need to furnish to the patient and the family, and how many times? How do you record it? How do you mention it? How do you store it? Now, those are the things which come to our mind when we think about consents. If you see the last line in red, what we normally say that patient ne consent diya. Did the patient give consent? So consent is to be administered by RMP. RMP is a registered medical practitioner. So every doctor who is registered with the Medical Council of India are RMPs. So when I use the word RMP is all doctors. When I use the word physician is all the doctors. So consent is to be administered. So we need to administer the consent. We need to explain everything to the patient, to the family. It's not that you give the paper to them and they sign the consent, so they have given consent. So this is something we need to remember, that consent is the responsibility of the treating doctor. It is not the responsibility of the family. It is not the responsibility of the patient, and not at all the responsibility of the hospital that we are working in. Now, yeah. So what are the 4 legal perspectives of consent? The beneficence, non-maleficence, autonomy, and justice. So just in brief, so beneficence is we do any procedure, diagnostic, therapeutic, or surgery to maximize the benefit and minimize the harm. So that is the beneficence. Then comes the non-maleficence, primum non nocere. So any procedure has to be done. It is assumed that it is being done in the best interest of the patient without causing extra harm. So we should not harm the patient. So non-maleficence, the doctor should not have any malafide intentions in his mind when he is treating the patient. Then that is also a significant and important part of the consent. Autonomy is like every individual is autonomous. Every individual is free to take the decision on their own, especially when he is adult, when he is conscious, where he is completely into his mind. And justice. So that's like everybody should be treated as per the Constitution of India. Every human being, every individual, every citizen should be treated equally. There should not be different treatment for different class of people, different gender, different socio-economical status. So again, consent is a teamwork. So how I just told that consent is to be administered by the RMP or the physician, but how it is a teamwork? Now, if I'm sitting in a clinic, I see a patient with a brain tumor. I explain everything to the family. I write down in the paper regarding the type of surgery, the options, alternative, all the fundamental things that we just discussed. So that is a job that I did. Then it comes the process of paperwork by the nurse. Then it comes when I see the patient in the OPD, we don't sign the consent form for surgery when the patient is still in the OPD. So it has to be done by the team members in the indoor hospital or in the ward or in the ICU, which has to be again verified by me. So consent is not something that just a nurse will go and hand over the paper, they get it signed, and the consent is done. Now, consent is a dynamic process. Now, how it is dynamic process? It's a word given. Everybody knows how the consent is being done. Say, for example, patient is admitted under my care for a brain tumor surgery. So I explain them everything about the brain tumor. The consent has been administered by me or my colleague for a brain tumor surgery next day. Before surgery, we do a CT scan or MRI, and we find that patient has got significant hydrocephalus, which needs either shunt surgery along with the tumor surgery, or only shunt surgery and the tumor surgery has to be done later on. Now, if I'm adding anything, if I'm changing the plan, even if I'm changing the date, if I have taken the consent for surgery tomorrow, and if you are switching the date, we need to take a new consent. So consent is not just like एक बार consent ले लिया and it will safeguard you for the rest of the life. No, the thing, it has to be reconsented. It's not necessarily written or recorded. That I'll come later on. What are the major components of consent? As I told, patient has to be fully aware, conscious, and into his mind. So it's a mindfulness and no undue influence. So, like you'll say, what is influence in consent? Like, patient is giving consent on his own. But whether the patient give consent on his own without any pressure or with some psychological stress, mindfulness is the patient and family understand. So it has to be in very clear language, very vernacular language and simple words, no jargons during consenting. So the purpose, as I told you, there are a lot of purposes of consent, but the most important, I need to highlight and clear the myth that consent does not make physician immune to litigation. We as a clinicians, we always feel if patient had problem, patient had complication, unfortunately patient passed away, patient had loss of limb or some neurological deficit, say for example, but I had consented the patient. So I am immune to problems, I'll be safe, nobody can sue me in the court. It is wrong. Consent is just passing on information. The good thing about consent, the red words, that it shifts the burden to the patient. Now, if they have consented properly, now a catch which is safe for the doctors or good for the doctors, it shifts the burden to the patient to prove that the communication was inadequate, although things are written there. But if the patient or the family, they claim that the information was not given to us properly, you are not explained, and the paper that we have signed is not in our vernacular language, we don't understand. We just signed the paper in emergency, patient came for emergency, they required surgery, डॉक्टर ने बोला कि तुरंत सर्जरी नहीं करेंगे तो मर जाएगा, ये वो. That's what we unfortunately we see in our those social media stories and movies. So but it shifts the burden to the patient and the family to prove that doctor did not convey properly. So consent definitely necessary, and properly taken consent will save your life. So what are the consent types? So these are basic consent types: implied consent, expressed consent, informed consent, surrogate consent, opt-out consent. So I think that the car is going in the top gear now, like you're getting confused that there was consent, then came the informed consent. Now we have got 5 different things. I'll just go through them. Sorry. So implied consent is just like you have invited me for this lecture. So it is implied that I agreed to join the lecture. It is implied that you agree to whatever I'm going to talk. So whenever a patient enters the clinician's clinic or office or OPD, it is assumed that patient has given consent to be examined by you, to be treated by you. So you don't need paperwork for that. It is implied. Implied means it is proven. It is proven. It is seen that patient has given consent for you treating him or her. Expressed. So implied is just a action. Express consent, you need to intimate the patient. When you are doing an intimate examination or PR or PV examination, we need consent. You can't just ask the patient to just turn around and do a PR examination. It's awful. It's invasive. So verbal communication. Expressed consent is a verbal communication between a clinician and a patient, which will soothe the communication, which will make the patient comfortable, which will increase the confidence of patient in doctor. You don't need necessarily a written thing for these things. But if you are doing an invasive thing, you need written things. What is surrogate consent? Now, these are the a few category of patients whose consent is considered invalid. What is that? In emergency case where the patient is unconscious or the patient is traumatized, patient is bleeding, that is a time when you don't go to the patient and explain for consent. Then the family, first family, a lot of other legal formalities for that, but the family can give consent. Uh, Advance directive. So ADR is when the person has already declared what is to be done, or we call it a living will. If somebody has declared that if I get a stroke, don't intubate me. If I get critical, don't put me on a ventilator. Then that is an advance directive. Again, there are different laws for that. So if there is an advance directive, the surrogate consent is uh, is valid. Children. In children, the parental consent is valid. I'll come to the point like what is children for a legal thing. And person with a mental illness. If there is a person with a mental illness who is not mindful, he or she cannot give consent for himself. So in that case, the surrogate consent is valid. Now, I told you these are the types of consent. So the question would be, हमको करना क्या है? Like, what is what we need to follow? So for routine treatment, just implied consent. Routine treatment. Patient comes to with a shardi khansi or some basic ailments. You prescribe some medicine. You prescribe some test. It's an implied consent. Expressed is better. So write, explain the things. It's a detailed treatment, like patient getting admitted for say PUO, pyrex of unknown origin. You are investigating, you are treating, you are giving antibiotics, you are doing some test daily. Then it has to be expressed, it has to be written, so that the tomorrow in the court of law you can say that I was following these steps in the best interest of the patient. Now it's a complex treatment. Again, there is no definition of complex treatment, but when there is surgery, when there is risk involved, when there is blood transfusion to be done, when there is an invasive procedure, then obviously written informed consent is better. So either on a personal note, what I do, I write everything in the OPD paper, and the same things are script in the indoor paper when the patient gets admitted. So there is no lapse in communication. Sometimes what we tell the patient and the family in OPD, we not necessarily remember when the patient was in the hospital for surgery. So writing everything will take your 5-10 minutes extra. We feel in a busy practice, like, if a physician is seeing 50, 60 patients a day in a OPD session, then it is not possible, but still it is necessary. Maybe down the line, after a couple of years, everybody will start doing this. So informed consent has to be taken for all the things that I just told. Any procedure, anything which needs scalpel, any cuts, any irradiation, chemotherapy, some biopsies, dye injections, myelograms, invasive radiology procedure. Now vaccines. Vaccines, we don't take written consent. That was a question I think Dr. Piyush we had discussed during our sessions. That none of the pediatricians would take consent for vaccines. But it is assumed that the child has come for vaccine, you are giving vaccine and you are explaining the things. Still, a lot of kids, they get complication after vaccination. So maybe that time will also come when the parents need to consent for individual vaccine when they go to a pediatrician. So tough time ahead. So I told my colleague or my
Dr.
somebody
Gopal,
needs
it's
to.
already Dr. Gopal, it's already 5, huh?
Yeah, I'll be 10 minutes extra. I'm done.
Okay.
So what are the things you have to include? It's not like patient is suffering from appendicitis and you need to undergo appendicectomy. You need to include what is the primary diagnosis, if at all we know. If it is exploratory laparotomy, we don't know the diagnosis, but what is our current running diagnosis? What is the nature and purpose of the proposed treatment? Am I doing a open surgery? Am I doing a laparoscopic surgery? What are the pros and cons? What is the risk of open surgery versus laparoscopy? What is the benefit of open surgery versus laparoscopy? What are the alternative treatments available? Whether we can control the current appendicitis with anti-inflammatories and antibiotics? Yes. Then what is the deadline of treatment? What is the deadline of surgery? And risk and benefit of all. And financial, again, there is no ruling to mention cost involved in the consent. If you want to involve, probably it is your discretion, but there is no rule to involve that you'll have to spend this much money in the hospital. Now, one more flaws that we have seen, there is a standard consent form in the hospital which goes to every floor, every department, every sections, even for endoscopy, even for radiology, even for surgery. The same consent form is used for appendicectomy and the bypass surgery. It has to be a disease-specific consent, which is available online, and you can use that disease-specific, or you can customize your own disease-specific consent according to the culture and the language. It has to be simplified. No jargons in the consent form. Very simplified in vernacular. Easy to understand for general person. And it has to be signed by patient or legal guardian. Normally, we get the consent signed by the patient's family. When the patient is sitting and sipping coffee, we get the consent signed by the family. It has to be the patient or legal guardian. Now, witness, it's a questionable thing. But yes, to witness in a major surgery or a resective surgery, or when you're going to remove a part of the body, it has to be a free consent. So free consent is force free. You cannot force the patient that you sign the paper, otherwise you will die. Fraud free. We should give appropriate and lenient information to the patient. So there should not be any fraud or deceit or misinformation in the consent. It's a coercion free. Like 3 people sitting in front of one patient and one family relative, and forcing them to consent unless it is emergency. Unless it is emergency, it should be coercion free. Constraint free. Like you need to sign within half an hour, otherwise we will not do surgery. That is a constraint. It should be constraint free. Patient should be having a right to refuse the treatment. Patient should have right to choose alternative treatment like laparoscopy versus open appendicectomy, or conservative versus surgical. And right to recall. What is right to recall? Like today, patient is admitted, patient wants surgery for a brain tumor. Patient is admitted, pre-op investigations are done, and tomorrow morning, when the patient comes to the operation theater and he suddenly says that I am little scared, I don't want to get operated. So that is a refusal to get treated. The patient has all the rights to recall the consent. I'll skip the case studies, but primarily all these case studies unfortunately connected to the obstetric and gynecology section of our medical fraternity, which are usually busy running practices. And there is a significant number of malpractice cases against the same fraternity, primarily because they deal with very critical age group, especially the childbearing females. So Samira Kohli versus Prabha Manchanda, when surgery was done, extended surgery was done without patient's consent, and patient underwent a hysterectomy and oophorectomy. She was unmarried. The doctor lost the case. Another case was Janki Kumar versus Sarfunisa. Again, the same problems. So these were the cases. Probably I'll share with Dr. Piyush, and you can just run through the cases fast through Google, where the doctors did a proper job, but they lost the case because the explanation, the paperwork, everything was inappropriate. It was not faulty, it was inappropriate. So the consent should have date, time, who signed the consent. It's not just like friend of the patient, but brother of the patient, elder brother, younger brother, what is the name of the patient, and all. Again, the things that we just discussed, everything which has been explained to the patient in the OPD chamber has to be written in the consent paper before procedure, before surgery. So these are the consent papers which have no validity when it goes to the court of law. If it is a blanket consent, the same consent paper for every surgery. Now, combined surgery and anesthesia, it has to be a separate consent for anesthesia, separate consent for surgery, separate consent for repeat procedure, separate consent for extension of the procedure, separate consent for blood transfusion. Like everything has to be a separate consent. So anything, if you club the different consents in one paper, then it has no value in the court of law, and we are liable to problems. Yeah. So this little important and interesting slide. Less than 12 years for there are a lot of hospitals which consider more than 16 as an adult, less than 16 as pediatric. The pediatricians feel more than less than 16 is pediatric age group. The physicians, adult physicians feel 14 is the cutoff. But the law says below 12 years of age, the consent has to be by the parents or the legal guardian. Above 18 years, it has to be the patient. And between 12 to 18, a child or a patient can consent or of if he or she has sufficient understanding. So this is again goes to the discretion of the family, discretion of the physician. But legally, less than 12, if you do a procedure with patient signing, then we invite problems. Obviously, the consent is not needed when you are doing the emergency procedure, life-saving procedures like burr hole. When the family is not around, we need to do a craniotomy for evacuation of hematoma. If there is an additional surgery, if I'm doing a aneurysm surgery and during surgery I find there is another aneurysm which has ruptured and it needs to be fixed immediately, I should not waste time of going out in the operation theater talking to the patient. We can always talk to the family later on if it is something which is a incidental finding or something which needs to be done to save patient's life. Court order cases is like a POXO case where the minor girl has got pregnant by rape, and the court orders the doctor to perform the MTV procedure. Then you don't need extra consent. Vaccines, mandatory vaccines, you don't need consent. We all have seen quarantine things during the COVID, so I don't need to explain those things. Now, mental health conditions, like those two things I'll leave because it's quite a separate lecture of treating people with mental health condition. But yes, severe mental health condition, we don't need consent to treat. Now, there's a fashion that we take a video consent of everything and then we feel we are safe. The fact is, there should not be a video recording in the OPD chamber, either from the doctor side or the patient side. If you're putting if you're putting a CCTV in our consulting room, we need to display a board that you are under CCTV surveillance, and we need to tell the family that the consent is being recorded. But yes, if it has been recorded with permission of the patient and the family, then and you have explained it properly. Now, if you take detailed consent and you have forgotten to mention something and you have recorded the thing, if that goes to the evidence, if that goes to the court as evidence, and you have not mentioned, then you are in trouble. So the more technology, more detailed consent you take, it might boomerang and create problem for us. So just concluding slides. We all feel that patient has come to us, let's take consent and take for OT. First, we need to build trust before legal forum. The patient has to be treated, greeted. Patient needs to understand the doctor is here to treat me and make me feel better. Once they have developed the confidence, then comes the legal formality. If you have not done the trust building, do the legal formalities, then either the patient will run away or the patient gets a complication, you are in trouble. There is no optimum information. So you need to give information based on your level of confidence and the understanding of the patient, making sure that they are given appropriate information about the major risk, major complications. Don't skip major risk. Like if I'm doing a pituitary surgery endoscopic, and if I don't explain about the meningitis of CSF rhinorrhea, then I am taking my own risk. Although the possibility is say 5%, but it is known, it is common. So we need to explain the common major risk without fail. Risk and complication, again, when I counsel my family, I say there are certain inevitable problems which can happen after this surgery. That is the risk of the surgery. And complication is something which should not have happened. So risk is inevitable, part and parcel of the treatment. Complication is something beyond what we would normally expect. So that also has to be part of the consent. So it should be honest communication. Again, doctor has to understand the consent is not a license to dash dash dash. I hope everybody understands. It is an ethical and legal requirement to consent. It's not only legal, it is ethical. We need to understand ethical and legal requirement to consent before going for a procedure or a surgery. Don't take it easy. Consent is not something that just nurse ne le liya, medical assistant ne le liya. It has to be by the physician. The last thing is self-written consent. When people have been telling that I got the consent written by the patient, which is good. It's not very common practice, but it is good. So if the patient writes the thing that you dictate and patient gives consent, then probably it has got the maximum validity as compared to any other consent forms. Thank you. You can download few consents which have been adapted, especially for the ENT procedures. The same way there are few forms of consent. I think Dr. Piyush can also share with you for every different specialty, which can streamline the whole process, and it will make the life of a hospital management very easy to avoid these litigation things. Thank you very much.
Thank you, Dr. Gopal, for such a nice lecture. It was quite informative, as always. You are so descriptive and so particular about a lot many things. And like your last slide says, minds are locked up stores, only questions open them. So I hope you have opened a Pandora's box when it comes to this topic that is quite burning right now across the country. Any questions from anyone? I hope all have been very good participants during this lecture. So, Dr.
It was a wrong.
Akshata, yes.
4 p.m. is a very crucial time for most of the people. If you're not given tea on time, you might be dozing.
Yeah, it's a very good time. Most of the cameras are off, so they must be having the tea then. But then it's a good time to keep yourself awake. It's such a nice lecture. But yeah, Dr. Aparna, Dr. Akshata, anything else on Mr. Pramod?
Thank you, Dr. Gopal. I'm Dr. Mamta this side from Gangaram Hospital.
Hi, Dr. Mamta.
Yeah. So congratulations for a wonderful presentation. It was very informative. So I have two questions.
Yeah, please.
You mentioned about like suppose some patient is schizophrenic and some surgical or any procedure has to be done upon him. So can his consent be taken as valid, or does he need something else?
Okay. So as I told that there is a separate talk for the mental health thing, like treating people with a mental thing. But there are conditions where say the patient is suffering from bipolar disorder or schizophrenia, where sometimes most of the time the patient is absolutely normal. So if the consent has been done during the phase that patient is normal, and it is proven that the communication was done appropriately, then the consent is valid. If the consent has been done during the phase that patient is unstable, the patient has come to the hospital with the acute episode of schizophrenia, then probably the consent that patient had given previously will not stand valid. So when the patient comes to us, when we treat the patient, when we consent the patient, at that particular moment of time, the state of mind of the patient is most important regarding the validity of the consent. Dr. Piyush, your thought on this?
Yeah, your points are very true. But in such a condition, what I would suggest is like what we learned from that lecture is when you're talking of bipolar disorder or schizophrenia, the patient can negate the consent that is already given previously. So it would always be better if you put up a witness during the consent when the patient is in a normal state of mind, that the patient has given this in total clear conscious state of mind. And that is actually a valid consent which can be accepted with a witness support, favoring that the patient is in a normal state of mind.
Okay. So can I ask one more question?
Sure.
Yeah, please go ahead.
So when any patient is admitted for any procedure or any other illness, So there are a lot of battery of tests or diagnostics come into play. So whatever data or whatever information we collect during this process, so is it mandatory to be mentioned in the consent form that whatever information we will gather through all the test reports and all the diagnostic results can be used for academic purpose or epidemiological studies or something? Is it mandatory?
Yeah, putting that patient's data will be used for teaching purpose or academic purpose or research purpose, that is necessary. But the thing is, there has been cases where the tissue was used for some research purpose, or which could be used for monetary gain or commercialization. That is not allowed. If it has been used purely for the research purpose, then it is allowed. Investigations without disclosing patient's identity, that is allowed. But using that material for commercial is legally not allowed.
Right.
You know,
So you
for
mean to say
monitoring
if we
purpose.
want to, right. So you mean to say if we want to do some prospective study on basis of those results or those data, that is acceptable, right?
Yes.
Yeah, Madam Ismail, there are two parts to this part where the consent is derived. Normally, when you're going for a blood test, that, as Dr. Gopal said, is an implied consent and the patient has come to the hospital for
No,
investigations. So obviously, that is.
no, my
But when
question,
you're talking of
yeah.
the research part or the patient's data is being used for some research or any other purpose, if you are using the patient's demographics, that is the age, the sex, or the contact details, or anything which can lead to the identification of the patient, then in such a condition, consent is necessary. If you are using unrecognized data, then the consent is not required.
Okay. So suppose we have got some sample from some patient and we want to
Yeah.
do some additional test on then because additional test on that particular sample.
Okay.
So without patient's consent, because those are with the patient has given consent to only the test for which that patient was billed, right?
Yeah. Okay.
And
Yes.
If you're sharing the
after,
information with some other third party, then it should be unrecognized if you have not taken a consent. That's all.
no, my question is suppose some patient comes to my hospitals, X
Okay.
investigations were done. So now I want to
Yeah.
add on Y investigation to come to some conclusive diagnosis or to done to part of some research study. So I am not using it
Yeah.
for commercial purpose, but I am using it for some extra
Research purpose.
conclusion which I want to derive. So in
Then
that
you need a
case,
consent. Yes.
do I need
Yes.
to
You need a
inform
consent.
patient that I am performing these extra
Yes.
tests on
Yes.
your sample?
Yes.
Right,
Yes.
right.
Yes.
Yeah, madam. Say for example, I have submitted a patient's specimen for glioma histopathology, and
Mm-hmm.
it comes as a glioblastoma grade 4 WHO. Then we ask
Mm-hmm.
for immunohistochemistry and you do ISC study P53 and ATRX and all. But if you want to use the tissue for some other research, which can be used by a pharmaceutical company for that chemotherapy things or radiation things or some adjuvant therapy, then you need a extra consent from the patient and or the family, uh, whether you are allowed to do it or not. So for that, as Dr. Piyush said, you need extra consent if you want to run some test, uh, either for
No,
research
not for
purpose.
commercial purpose, but only for
Even
academic
for research.
activity. Suppose,
Yeah. Yeah.
But
You will need a madam consent.
madam,
That
the
is, you
problem
need
is,
that consent.
yeah, madam, the problem is that research will eventually go in commercial activity. Like there have been cases noted for that. And it is not like my feeling or Dr. Piyush's feeling. There have been cases like this. Once you collect the data of 100 or 150, 200, 500 CSF studies, normal CSF studies or glioma studies, eventually somebody is waiting to extract that data which can be used
yes,
for commercial purpose. So extra
or to
consent
develop
is,
some more biomarkers or some
yeah,
kind
yeah,
of.
Yeah.
yeah,
Exactly.
absolutely,
Exactly. Yeah. True.
absolutely.
That's
Absolutely.
See,
So
that's
thank you
what the
very
data
much for
mining things or this uh, data collection is happening. Somebody is collecting your data and eventually he has got a data of say 1 million people, so it becomes an asset for him. He can sell that data for
yeah,
huge
yeah.
amount.
There's one
Yes,
more law that
absolutely.
is coming into there's one more law that is coming into play in the coming few months is one of the DPDP Act. That is the Digital Once that act
Okay.
is it's already passed by the parliament, once it comes into force, all these things where you're sending data of the patient on WhatsApp, social media, or through emails has to be restricted to only the patient without because we cannot share the data of a patient, even his blood reports, without his permission in future. So that also will be restricted in the coming few months.
Oh, that's actually very important also because people
true.
misuse these kind of power which
Reports,
they have being in medical fraternity, right?
yeah, exactly. True.
Actually, the rule in making is since 2 years, but now finally it is going to be implemented and implemented very strictly. Just like
Yeah.
HIPAA compliance in US, it's going to be very strict.
Right. So thank you. If any other question we will have, we will definitely catch you, request you to
Sure.
clarify our doubts.
Yeah,
Sure.
So
Thank you so
thank you.
much. Thank you, ma'am. Thank you so much.